Hey there, I'm Louisiana estate planning attorney, and I'm going to talk in this video about how to complete a Louisiana succession. All right, so a succession is necessary when someone has passed away. They own assets in their name. Those assets might include a home or real estate or bank accounts or investment accounts or a business interest. And maybe that person had a will, maybe they didn't, but they owned assets in their name. And so since they owned assets in their name when they died, those assets are going to be frozen. And so it's the succession, which other states call a probate, but we call it in Louisiana a succession. It's that succession that's necessary to get lawyers and judges and courts involved, because judges have to sign court orders ordering different third parties to release assets to the appropriate heirs or beneficiaries. Okay, so here's the steps on completing a succession. It usually starts when someone passes away and one of the family members, it might be a spouse, it might be an adult child, one of the heirs finds out, in inquiring about the assets, one of the heirs finds out that an asset is frozen. Maybe they go to the bank and the bank says, "I'm sorry, your father's account is frozen. You've got to go through a succession." Maybe a child went to a brokerage firm and the brokerage firm told the child, "I'm sorry, your father's account's frozen. You've got to go through a succession." Maybe the son tried to sell the father's house and the title attorney said, "I'm sorry, you can't sell the house. The title's frozen. You need to do a succession." So what happens when heirs find out that they need to do a succession? Well, it usually starts with a conversation with a Louisiana succession lawyer, not unlike myself. When you have that discussion with the succession lawyer, be prepared to discuss a number of things. Be prepared to produce a copy of the will so that the terms of the will can be discussed. Terms like who's named in the will as the executor, who are the beneficiaries that are named in the will. Be prepared to discuss the assets of the person who passed away. Did they own a home? Did they own real estate? Did they have accounts at financial institutions? Did they own a business? Be prepared to discuss the assets. Also be prepared to discuss the relationships of all of those parties who are involved in the succession. Does everyone get along? Is everyone supportive of one another? Is there kind of a wild person out there who's gonna cause problems no matter what the circumstances are? And then, after there's conversations about all of those things, the lawyer should give you an idea of the series of steps that are needed to take place to go from where you are now, where someone just passed away and everything's frozen, to getting everything settled, all of the rules being followed, the procedures being followed, and everyone who's entitled to inherit, having their inheritance, in the right format. So here's the steps that are typically involved. First, if there's a will, the will likely name an executor. So there's a procedure to go through to file the will at the courthouse and have a judge declare that the will is valid, that it meets the formality requirements, which if it's a typed up will, it's to meet the formality requirements, it's got to be a will in the form of what's called a notarial testament. It's typed up, it's signed on each page, it's notarized, it's also witnessed by two people, it has a special attestation clause at the end. Meet all those validity requirements, it's a notarial testament, and a judge will sign an order that it's a valid will. Also, a judge will sign an order confirming the position of the executor. So whoever was named in the will file these petitions, or the lawyer will, and a judge will sign a court order ordering that person is actually the executor. Then next, that court confirmed executor with the paperwork that the clerk of court issues after the judge signs the appropriate first round of orders. The executor then goes and establishes one or more estate accounts at a bank or a financial institution. So once that takes place, then that executor moves money from the deceased's accounts, which that executor can do with the appropriate court orders. Those banks will release those funds to the executor, and the executor will deposit those funds into an estate account. Then the executor will, and every succession is different based on assets, debts, parties, who's involved, how much. But the next step is typically to pay the debts of the decedent. So maybe the person who died had some credit card debts, some funeral expenses to pay, maybe had some car loan expense that needed to be paid. So the executor will collect the the estate funds, and then use those funds to pay estate debts. The executor may also need to sell certain estate assets, such as a vehicle that the deceased owned or the home of the deceased. Oftentimes you find the executor will sell those assets, pool that money into the estate account to be divided up among the heirs. And also, as part of the succession process, it's required that what's called a detailed descriptive list or an inventory of all succession assets and debts be prepared. So the lawyer's office prepares that. You have to supply all of the information so that the lawyer's office can prepare the required detailed descriptive list of assets and debts. And then finally, more court paperwork is filed, signed off by the parties, often called a petition for possession, and then which is a petition filed at the courthouse asking a judge to sign a judgment of possession, which is where a judge orders third parties and orders the executor to divvy up the estate assets in accordance with the terms of the will, if there was a will, or that judgment of possession orders the court-appointed administrator, if there was no will, to divide the assets up to the heirs that the state says are entitled to receive the assets of the decedent. Also want to make sure that any final income taxes that may be due are paid. Now, how much does all of this cost? Good question. The expense involved in a succession depends. It depends in large part. Of course, there's court costs to be paid that have to be paid to the clerk of court in the parish where the deceased lived. But in addition to that, there's also going to be lawyer charges. How much will those be? That could depend on the whim of the attorney. The attorney might say, we'll bill you by the hour. Every time we spend 15 minutes, we'll bill you a quarter of an hour. Our hourly rate is $500 or whatever it might be. So maybe a lawyer will tell you they'll bill by the hour. You never know how much it's going to be until the very end, and then you're surprised. Or a lawyer might say, I'm going to bill the estate a percentage of the value of the estate. So got to watch out for that. And then other lawyers will say, I'm going to let you know in advance what the fixed expense will be, and then we'll just get you through the whole thing based on that fixed expense. What's better, what's worse, you be the judge, but be prepared for any of those conversations with the attorney who's going to be helping the heirs go through that succession procedure. All right, well, like I said, everyone is different. There's different relationships. There's different provisions in the will. There's different types of assets. There's different types of debts. And so each one is different. I've handled many, many hundreds of them over the years, and no two have been the same, but that should give you an idea of generally what's involved in completing a succession from start to finish. Now just let's make sure you like, subscribe, comment, all that good stuff, and we'll see you next time.